Afternoon and welcome to our webinar. Liability management exercises have been the hottest trend and the most frequent discussion topic in the restructuring market for years. The frequency of these transactions as ways to deal with liquidity shortfalls or over leverage has become commonplace, and the evolution of the types of LME forms has increased significantly. What started as mostly up tiers and drop downs has had to make room for double dips and pari plus transactions. And all the while, as the frequency and types of LMEs has expanded, there was litigation pending that could undermine the very legality of these exercises. On this past New Year's Eve, while we were getting ready for the ball to drop in nearby Times Square, the Fifth Circuit and the New York Appellate Division each issued long-awaited opinions in the Serta and Mitel cases, respectively, that will help shape the future of LMEs to come. In particular, it will guide the way we view and interpret pro rata sharing provisions and their exceptions, which has been the cornerstone of LME disputes, and it sets some boundaries that will frame future disputes as well. So it's big news in the restructuring community, and it's been a central topic of discussions in articles and on panels like this. So we want to make ours a little different. We'll spend some time talking about the path of LMEs going forward in light of these opinions, how to avoid pitfalls, but we'll also talk about what this means in the present as well. These two are not the only LME challenge cases pending, nor the only decisions on these topics. So we want to give you a more fuller picture of the legal landscape. We also want to drill down on what this means for the potential winners and losers in these litigations. What are the remedies and against whom? Market participants need to factor this into the real cost of participating or not participating in an LME transaction. I'm Ron DeVersa. I'm the chair of Orrick's Restructuring Group. I have a very distinguished panel of colleagues here. Meredith Dawson is a partner in Orrick's Banking and Finance Group. And we have Mike Trenton and Nick Sabatino, both from Orrick's Restructuring Group. So let's kick it off with a brief dive into the types of LMEs, and I'm going to hand it over to Meredith.
Yeah, thanks, Ron. You mentioned LMEs have been the hottest trend in the market over recent years, and I will add that that's clearly just going to continue, and that's the case for a couple of different reasons. One being just the continued uncertainty in the market, but a big one just being that sponsor-driven deals are competitive, and covenants and amendment rights that make these transactions possible are very highly negotiated. LMEs are often characterized, I think, in a negative light as lender-on-lender violence. But the fact of the matter is, from the borrower's perspective in particular, there's real value in having flexibility to tap new liquidity and restructure liabilities. So we're going to discuss more today. Serta and Mitel are very impactful decisions, I think, in terms of the risk analysis for certain LME strategies, but don't shut the door on these transactions either. Just to lay some groundwork in terms of the types of LMEs, given the discussion on this topic recently, I think most of us know by now that Serta and Mitel both involve an uptier exchange, which is just one type of liability management transaction. And I'll come back to that one in a minute. Other common strategies include drop downs, right, where a borrower moves assets into an unrestricted subsidiary or otherwise outside of the credit group in order to use that same property as collateral for new debt. That debt is then structurally senior to the existing loans, at least with regard to the value of the collateral that's been repledged as support for the new money. Another that's discussed often is the double dip. So you've got lenders provide a secured loan to a borrower who then uses those proceeds to make an intercompany loan to an affiliate. So those lenders now have both a direct claim against the obligors for their loan, as well as an indirect claim against the affiliate obligors by way of that intercompany loan. You may have also have some guarantees on the new money from different or additional obligors in what's referred to as a pari plus transaction. But the bottom line is that it doesn't have to have a catchy name to be effective. Any holes in the loan documents, whether those are market-driven or unique to an individual transaction, if there's an opportunity to re-leverage the same assets and provide more liquidity, you've got creative borrowers, you've got savvy lawyers, and they're going to exploit those. So we're going to keep talking about different LME strategies and tactics, undoubtedly. We can go to the next slide, which brings us back to Serta and Mitel for today. As I mentioned, both of these involved a non-pro rata uptier exchange, which at its core involves amending the existing loan documents using just required lender consent, typically just a majority, to permit the incurrence of new super priority debt. And in both cases, the participating lenders that provided the new money also then exchanged their existing loans for debt that ranked below the new money but ahead of the non-participating lenders. I'll turn it over, I think, I'll let Nick lead us through.
Perfect.
Sort of after.
Yeah, thank you very much, Meredith. You can go to the next slide. So, Serta obviously is a very important case in this kind of area of liability management transactions, specifically uptiers. And as Ron mentioned, we're going to talk a little bit about where we think it might be going next. But in order to do that, we want to give a little bit of background and kind of lay the groundwork for how we got here. So, Serta was one of the largest bedding manufacturers and distributors in North America, but they had started facing increased pressure from competitors with a direct-to-consumer business model in recent years. So in 2016, they had entered into a new credit facility that consisted of a $1.95 billion first lien loan, $450 million second lien, and a revolver. In 2020, the company started facing some liquidity constraints brought on even before the COVID-19 pandemic, and then they were certainly exacerbated by the pandemic. And so competing proposals for a potential liability management exercise started to surface in early 2020, March, April timeframe, actually from two different groups of lenders. Ultimately, the company went with the uptier that was proposed by a group of participating lenders, what we'll call the PTL lenders. You can go to the next slide. So the transaction it involved the amendment of the existing credit agreement to permit new super priority debt, and the participating lenders and Serta entering into an exchange agreement pursuant to which the participating lenders provided $200 million in new money, which were then became first lien, first out loans, and they exchanged $1.2 billion of their old loans for $875 million of new first lien, second out loans. So they took a slight discount, they put in some new money, but they vaulted themselves kind of to the top of the priority structure. And then the transaction also included an indemnification by the borrower of the participating lenders for any liability arising out of a transaction. So it provided potential protection for the participating lenders for participating. Go ahead to the next slide. So under the 2016 documents, most amendments under this particular credit facility required only approval of a simple majority of lenders. Now, it's important to realize that despite the pro rata treatment being the source of litigation here, at a more basic level, what the excluded lenders are really objecting to in this transaction is not so much the pro rata payment rights, which were never changed, but rather the subordination of their first lien loans without their consent. But anti-subordination or incurrence of priming debt was not a sacred right that was protected under this credit agreement, as is the case with a lot of credit documents from this kind of 2016 vintage where the covenants were pretty loose. But a bare majority of lenders could approve an amendment that permitted changes allowing senior indebtedness, which is what happened here. The pro rata sharing provisions really focus on the second step of the process, which was the exchanging of old loans for new super priority loans. And the sacred right, as it's commonly referred to under the credit agreement that was impacted by that transaction, was what you see on the screen here, which is the provision that all payments should be allocated pro rata among the lenders, and that all lenders or all affected lenders must give their consent to any amendment that waives, amends, modifies these provisions that would alter the pro rata sharing of payments. But there were exceptions, which you also see in the screen here from the credit agreement. And so any lender could assign all or a portion of its loans under the agreement to any affiliated lender, which included Serta, on a non-pro rata basis if it was done through a Dutch auction that was open to all lenders, or through the open market purchase process, which, as most of you I'm sure already know, that is really became the hook here in this case. So in short, there were two ways that Serta could repay its loans without ratable sharing among the lenders. That was a Dutch auction or the open market purchase. the 2016 agreement did not define open market purchase. Go ahead to the next slide. So this transaction was early 2020, as I mentioned, and before it even closed, the litigation had already commenced with some of the non-participating lenders trying to stop this transaction because the cost is of one of these up tiers is borne pretty much entirely by the non-participating lenders. So they tried to stop it. They failed. The litigation continued. The transaction closed and the litigation continued for another 2 years with varying degrees of success at the early kind of motions to dismiss stage. Fast forward to January 2023, Serta files for bankruptcy. The very next day, Serta and certain of the participating lenders commenced an adversary proceeding against the excluded lenders, seeking declarations that basically the transaction was permitted and it did not, the transaction did not violate the implied covenant of good faith and fair dealing. The non-participating lenders, in response, they brought several counterclaims alleging breach of contract, breach of the implied covenant of good faith and fair dealing, and seeking declaratory relief. Go ahead. Next slide. So the bankruptcy court, Judge Jones gets the case. Initially, he grants partial summary judgment to Serta and the prevailing lenders on the issue of whether the term open market purchase was ambiguous. He found that the term was clear and unambiguous and that this was a valid open market purchase. He said he sits with these cases every day. He knew what that was. This felt like an open market purchase to him. And so it was an open market purchase and therefore did not violate the pro rata sharing provisions of the credit agreement. Interestingly, though, the litigation history around that particular phrase is kind of mixed. So in a prior New York State court action in Serta, actually, a New York judge had said that the open market purchase likely applied without concluding on it. In the board riders case, another liability management transaction that was litigated in New York State court, the judge found that the term open market purchase was ambiguous. And in fact, in Serta, in a separate Serta action in the Southern District of New York, Judge Fela denied Serta and the participating lenders' motion to dismiss because she found that the term open market purchase was ambiguous. So clearly there's some disagreement about what that means. Judge Jones didn't feel like it was ambiguous, though, and he got a hold of it. He said this was an open market purchase, so there was no breach of the pro rata sharing provisions of the credit agreement. So as Ron and Meredith alluded to, just on New Year's Eve, the Fifth Circuit issues its decision reversing. They found that this did not fall within the open market purchase exception. They said that the participating group had basically taken the position that there were two options for the company to repurchase debt, either a Dutch auction or everything else. And if what they said was true, then an open market purchase would basically swallow all kinds of all transactions, including the Dutch auction. They could label anything an open market purchase. And instead, an open market purchase means a specific market that is generally open to participation. And it is the place it takes place on such a market as is relevant for the purchase product. So here, that would be the secondary market for syndicated loans. So it would have to occur there to be an open market purchase. Now, one could argue that this was because the non-participating lenders had made their own offer for a transaction in early 2020. So this was, in essence, competition on an open market, and the terms of the competing offer set the price. But that was not how the Fifth Circuit viewed it. And, pretty strict interpretation that an open market in this case means the secondary market or the market for secondary loans. Also, as I mentioned, anti-subordination was not a sacred right here, and the Fifth Circuit made no real discussion of the subordination piece. They focused just on the exchange piece of the transaction. But that implies kind of broadly that subordination is not by itself a sacred right. And so if you have a transaction or a credit agreement that does not explicitly make subordination a protected right, you're probably not going to get much sympathy from the court. Equitable mootness also, the Fifth Circuit said it didn't apply here to their ability to excise the indemnity provision. I think equitable mootness, it generally prohibits review or disturbance of substantially consummated plans because it can be impossible to unscramble the egg. The Fifth Circuit kind of, cast doubt on the doctrine in general. They said, to the extent that it exists, It's a judge-created doctrine that constrains appellate review, but they're clearly not in favor of letting parties use it as both a sword and a shield, which is kind of what the participating lenders tried to do here, or so they found. And to that end, they excised the indemnity provision, found that it was an end run around Section 502E1B of the Bankruptcy Code, and they found that it also resulted in unequal treatment among members of the same class, which violated Section 1123A4 of the Bankruptcy Code. Go ahead to the next slide. So, kind of where does that leave us after Serta? I'm sorry. Well, number one, as mentioned, open market refers to a specific market for that type of asset, right? Up tiers that rely on a very broad interpretation of open market purchase are probably, no longer going to work, at least in the Fifth Circuit. Whereas those that maybe rely on simple purchase language or specifically include privately negotiated language may still work. And Mike is going to have some thoughts on that, I think, about, after this Mitel case as well. Also, equitable mootness may be more limited than previously believed. While unwinding a complete plan or sale or other transaction out of a bankruptcy case still seems pretty unlikely, as we'll discuss later, individual provisions now, like an indemnity, do seem like they're at risk and could be, excised with relative ease. And so you could have parties who end up attached to, really a bargained for plan or a bargained for contract, and it's missing one of the key provisions that they negotiated for. And then lastly, the equal treatment, I think, is actually pretty interesting because it could have really broad implications. The Fifth Circuit said that equal treatment implicates both opportunity and result. The participating lender said everybody in classes 3 and 4 are getting the same treatment. They're all receiving the indemnity, therefore it's fair. And the Fifth Circuit said that's not really fair because if they are in the class, but they didn't participate in the up-tier transaction because they acquired debt after the transaction, they're going to get no benefit from this indemnity. So they get it in theory, but it doesn't give them any benefit. They use the analogy of a plan that awarded an extra $5 million to every member of a class who had its headquarters in Louisiana, which would obviously be unequal treatment. But if the plan simply provided that every member of the same class gets a note promising payment of $5 million in 1 year if the member is headquartered in Louisiana, it looks different, but in reality, it's no different than the first option, and it results in unequal opportunity and result for the parties. So I think that raises some really interesting questions. Frequently we see plans issue reorganized equity, but what if one party receives a stake that gives them a controlling interest in the reorganized debtor? That's certainly more valuable than somebody who receives a smaller stake of reorganized equity. So does that result in an unequal result? I don't know. I think it's going to be interesting to see what attorneys and judges do with this going forward, and what arguments they can make.
Thank you, Nick. The New York court, the appellate court issued a decision on the same day in the Mitel case with a different outcome, but with slightly different and distinguishing facts. So Mike, tell us about that case and how this court, also applying New York law, came to a different conclusion.
Thanks, Ron. Yeah, so Mitel decision was out of the Appellate Division of the New York State Court, whereas Serta was a federal decision, obviously. And the decision was really short. It was 3 pages long only, and it was shortened to the point. Because of that, there was not much background discussed there, so I think it makes sense to go through some of the background that led to the court's decision. So Mitel was a Canada-based, is a Canada-based business communications company. It was acquired by Searchlight in 2018 through a leveraged buyout funded by about $1.1 billion in first lien syndicated debt and $260 million in second lien debt, both secured by the same collateral. And there was also a $90 million revolver. A few years later, at the end of 2021, the company partnered with another business called Ring Central, and Mitel sold to Ring Central some of its IP rights in exchange for cash and stock in Ring Central. Now, it's alleged in the litigation that Searchlight was telling the lenders certain lenders that they would be paid back early on their loans, and that the other proceeds from this deal would be used to acquire another company. However, when Ring Central stock sank, Mitel did not have the liquidity to pay down the debt or to fund the intended acquisition, which ultimately led to the uptier exchange. Next slide. Nick earlier discussed that in Serta, there were certain sacred rights provisions that related to the pro rata payment rights of the lenders. But there was not a sacred right provision that prevented the company from incurring senior debt. And the same was true in the Mitel documents. You'll see on the screen the sacred right provisions that were applicable and at issue, which was that an amendment to the agreement could not decrease or forgive the principal amount or extend the maturity or decrease the rate of interest without prior written consent of the affected lender. Qualified by the lender must be directly adversely affected by the amendment or modification. There was a similar provision that protected the pro rata sharing of payments. And like in Serta, there was a purchase exception. However, this exception is worded differently, and that matters quite a bit. And the language is below here. Essentially, under this exception, Mitel could purchase by way of assignment and become an assignee with respect to the term loans at any time and from time to time. And that would be an exception to the pro rata sacred right provision. Next slide. So the participating lenders used these provisions to their advantage and structured an uptier that's quite similar to Serta in terms of the steps and the structure. The participating lenders provide approximately $150 million in new money senior super priority loans to Mitel, constituting new first out debt. And they exchanged their first and second lien debt for new second out and third out debt at a slightly lower face amount, 94% on the first lien, 80% on the second lien, which I'll note was a premium to what the loans were trading at in the market at the time. Next slide, please. The excluded lenders didn't like this. They now sat behind over $800 million in senior debt, and they filed lawsuit in New York State Court. And the claims were similar to Serta, but there were some that were different. Declaratory judgment to invalidate the transaction, breach of contract against Mitel and the participating lenders, claims against Mitel and the participating lenders for breach of the implied covenant of good faith and fair dealing. They also sued the sponsor, Searchlight, and Credit Suisse was the agent and the revolver for tortious interference. And they sort of threw in a fraudulent transfer claim at the end of the complaint. The participating lenders moved to dismiss, filed a motion to dismiss at the trial court level, and the trial court dismissed all claims except for the declaratory judgment and breach of contract claims. In New York State Court, unlike in federal court, parties are permitted to appeal interlocutory orders. What that means is that the parties do not have to wait till the end of the case to file an appeal, and so both sides appealed the trial court's decision in this case. Next slide, please. So on New Year's Eve, the Appellate Division issued its decision. It found that all claims should be dismissed. As to the contractual claims, the court essentially found that the excluded lender's sacred rights were not impacted because the amendments did not directly affect their loans. They did not change the maturity, did not change the interest. And so any impact that was negative was indirect, and therefore it did not fall within the sacred rights provision. The court also found that the exchange portion of the transaction was a purchase within the pro rata exception. The court said there was no indication in the agreement that a refinancing or exchange cannot include a purchase, nor is there any indication that a purchase requires payment in full upfront in cash. So essentially, the excluded lenders were arguing that a purchase must be done in cash. The court said no, a debt exchange is sufficient to meet the plain meaning of the term purchase under the agreement. The appellate division also affirmed the dismissal of the implied covenant claims, finding that a reasonable person would not be justified in reading into the agreement a right that there should be no subordination of debt. And lastly, the court affirmed the dismissal of the tortious interference claims against the agent and Searchlight, finding, among other things, that they acted based on their own pre-existing interest in the debtor. Next slide, please. The takeaways. So Mitel, because of what it says and also because of what it doesn't say and how short the opinion is, sends a clear message that contractual language matters most in New York. Courts in New York may be unwilling to look past the explicit contractual provisions and read in rights and obligations that are not expressly included in the agreement. It's important to note that Mitel is the first significant higher court authority in New York on up-tier transactions. Obviously, as many of you know, most loan documents are governed by New York law. And in a federal dispute, such as in bankruptcy court, federal courts are required to apply New York law when interpreting New York contracts. The one caveat here is that under Supreme Court jurisprudence, a federal court is only required to apply the New York state court as decided by the highest court in the state. In New York, that's the Court of Appeals. And Mitel was an appellate division level decision. So it's not per se binding on federal courts applying New York law, but I think it would be prudent to expect that any federal court who's dealing with issues like this will show great deference to the appellate division's decision in this case.
Great. Thank you, Mike. Meredith, you're on the front lines and you deal with these provisions when they're being negotiated. So I'm interested in your observations, how the market perceived these litigations when they were pending and how they might respond now that these decisions are public.
Yeah, thanks. And this slide, I think, just shows just the differences in the language here. I think even though the language in Serta is arguably more prevalent across the loan documents that we've seen than the language in Mitel, there's a wide variation. So if you go pull 5 credit agreements off the shelf, I think you'll find that they don't all say the same thing in this regard. Debt buybacks, the voting rights, these are all negotiated just like the covenants are. So minority lenders have been scrutinizing the documents. I think there's reason to continue to do that. There's reason to continue to push to include some rules around buyback mechanics if those are unclear as they were in Mitel. Tight sacred rights provisions, capturing amendments that would have the effect of subordinating the liens or altering pro rata sharing and not just those that do so directly. But in the market, the sponsors and borrowers really do push for as much flexibility here as they can get, understandably so. So I think there will still be a fair amount of variation depending on how competitive the deal is, appetite of the lender group, and other factors. And that really, I think, is important. And I agree with Mike. The Mitel court says that, at least in New York, the court is going to uphold what's in your document. So if your document permits an uptier or permits another strategy, that door, and whether it's a trap door or an opportunity, depending on which side of the table you're sitting on, that door's still open. So undefined terms, other instances where there's a lack of clarity, certainly increases transaction risk for the participants in these transactions. Other strategies that we have seen run in the market, separate and apart from what's in the actual loan documents, as more attention is being paid to LMEs and these strategies in recent years. We are also seeing a push among lenders to organize under more formal cooperation agreements. That's happening a little bit earlier in the process. And that can also be an important tool, particularly in the context of an uptier or another transaction that would otherwise just require majority consent, because that'll require generally a supermajority among the lenders that are party to those agreements.
Great. Thank you, Meredith. Let's shift to remedies. So I know we've gotten a lot of questions from clients around what happens now if you're a non-participating lender or a participating lender in one of these litigations. So I'll turn it over to Nick and Mike. You talk about what types of remedies have been sought and awarded, what types of claims you might see in these cases going forward.
Yeah. I think that is obviously a very important part of the equation in evaluating the risk here. We all know lawyers love their Latin phrases. I haven't practiced Latin since Catholic school, so I'm not going to give this a shot. But the basic premise here, right, is that where there is a right, there's a remedy, meaning that wherever a legal right is violated, the law should provide a corresponding remedy or means of redress for the injured party. So while we've seen, as I think Meredith said, some optimism for the excluded lenders here, understanding, what the potential actual, remedy is really what makes it meaningful. Because if you get nothing, even though you win, it doesn't really help you out. So on the screen here, you see just kind of some of the claims that we are seeing asserted and the relief that we are seeing requested. These all kind of have varying degrees of success in the different litigations. The most common really is the breach of contract. Obviously, the argument there is you breached some provision of the either indenture or credit agreement, the underlying credit documents, and it's usually asserted against both the borrower and the participating lenders. The other really common one is the breach of implied covenant of good faith and fair dealing, which is implied in every contract. It has met with, I think, little success so far. Courts aren't all that sympathetic because these parties are sophisticated parties. And like Mike discussed in Mitel, if it's not in the contract, you probably shouldn't have expected it. And then I think from there, the claims, the tortious interference, equitable subordination, they actually kind of have seen worse and worse success the further down the line you go. And then the relief that is requested most of the time is money damages, which is kind of your typical remedy for breach of contract. And we'll talk a little bit later about how maybe, a court would go about deciding how to calculate that. It's, suffice to say, it can be tricky. Also parties, excluded lenders also want to see the transaction unwound. That gets harder and harder the further you move out past the closing, and especially if you go through bankruptcy and you're talking about equitable mootness, like it's really difficult for the court to do. Turnover, potentially in essence, the participating lenders received something that they were obligated to turn over under the credit documents. So the excluded lenders might see, instead of unwinding the transaction, say, hey, you just have to hand over what you received. And then really kind of the one so far, I think, that has been the most interesting hook is the declaratory relief. Basically seeking a declaration that the transaction, the up-tier transaction of the other liability management transaction, violated the credit agreement, and therefore it, either has to be unwound or was ineffective. And we saw that in Encora. And so to get a sense of what might happen in these cases, we're going to take a quick look at Encora and Robertshaw because they're two LME cases that have made it all the way to that stage. And then we'll come back and revisit Serta a little further. So we can go to the next slide. Without going too far into the background on Encora, it involved an up-tier transaction in 2022. There were a couple of steps. These were notes issued under an indenture as opposed to a credit agreement. So a little bit of a technical distinction there, but similar premise. And the underlying indenture there required a supermajority, 66 2/3% consent for any amendment that would have the effect of releasing collateral. The majority group, sort of shortly before the transaction, realized they didn't have 66 2/3 a majority, and so they had to undertake this kind of preliminary step that they added to the transaction of amending the indenture to issue additional notes, $250 million in additional notes, which they purchased, which then gave them the 66 2/3 majority. And then thereafter, they were able to go out and further amend the indentures to exchange their notes for new higher priority notes and strip the liens of the non-participating note holders. So the non-participating note holders brought many of the claims that we kind of just discussed in the prior slide, including breach of contract, breach of the implied covenant, and they sought declaratory relief. Go to the next slide, please. So after a very long trial, about 6 months, I think it was 35 days of testimony, Judge Isger found that the First Amendment to the indenture, the one that permitted the issuance of an additional $250 million of notes, had the effect of releasing the non-participating note holders' liens, even though that didn't actually happen until 2 steps later in the transaction. And even though amending the indenture to issue the additional debt didn't require a supermajority. So they had the majority they needed, but because when, Judge Isger found that this created an automatic series of dominoes, these transactions, when you look at all 4 steps together, he said that it had the effect of stripping the non-participating note holders' liens in their notes. And so what he ends up doing here, which is pretty, I think, novel. I think some people would say it was unexpected, and some people would say maybe even unfair if you were in a participating group here, surely. So he basically said that the 2022 transaction was not permitted. It violated the credit or the indenture, and it was as if it never even happened. And so he was very, very clear during the trial that towards the end of the trial, actually, when he decided where he was going with this, that he was not going to let that happen because it violated the indenture. And then he said, the worst thing I could do would be to turn around and now give the excluded note holders a general unsecured claim in the bankruptcy for which they'll probably get, a pittance under the plan. So instead, he reorders the entire capital structure. He says that the transaction basically never happened. He doesn't necessarily restore their liens, but he says that they were never stripped in the first place. And so the non-participating note holders, are back in the first lien position, along with, the participating note holders' old money. But the real kind of punishment here, I guess, if you will, for the participating note holders is they put in $250 million of new money. And they got essentially no credit for it. It ends up being a general unsecured claim under the plan. So it's kind of like the worst case scenario. You put in new money and get nothing for it. So that's, I think, a pretty tough pill to swallow. It looks like a pretty, I think, kind of radical remedy, I think some people would say. It was easier to do this in Cora or in Westco because this was pre-confirmation of the plan, right? This would be something that's probably very difficult to do in Serta. And we could talk about that more, but when you're pre-confirmation, you have a little bit of ability to kind of reorder the capital structure because you don't have to worry about things, like unscrambling the egg, like equitable mootness issues. So, I mean, that kind of a novel remedy, but I think Mike is going to talk about Robert Shaw, which same court, different judge, basically the same time, actually, pretty radically different outcome.
Yeah, thanks, Nick. So Robert Shaw was a case also in the Southern District of Texas, but it was before Judge Lopez, and it's particularly relevant here because the Serta remand is going back to Judge Lopez. So it's possible that what he did here could show signs of what he may do in Serta. So the transaction in Robert Shaw was not an uptier, although it did follow a prior uptier involving Invesco and another group of lenders. After that uptier, Invesco obtained a majority of the outstanding senior debt. And at the time, the company needed liquidity, and the sponsor and the minority group decided to engage in a transaction that would make Invesco the non-majority holder of the debt and essentially put it behind the new majority lenders. So Robert Shaw, its parent, created a subsidiary, and One Rock and other lenders provided a $228 million loan to the subsidiary, which upstreamed the proceeds to the debtor. The debtor used the proceeds to pay off a portion of Invesco's debt, which resulted in Invesco no longer holding a majority of the debt. Instead, the majority was held by the participating lenders. Robert Shaw and the participating lenders amended the credit agreements to arrange for Robert Shaw to issue new loans in order to prepay the subsidiary's funding. The end result was Invesco received $90 million for its debt, but it now sat behind the participating lenders and lost control. Next slide. Following the transaction, Invesco filed the suit in New York. The bankruptcy case followed, and the dispute went forward in the bankruptcy court through an adversary proceeding. The court found that the debtor breached the loan agreement because SF Funding, the subsidiary, qualified as a subsidiary restricted under the credit agreement and therefore was not permitted to issue debt. Invesco asked the court to reinstate its status as a majority lender, essentially unwinding the transaction similar to what Judge Isger did, and also sought claims for money damages, including $66 to $102 million in damages representing the value of the equity interest or take-back debt that Invesco would have received in a restructuring of Robert Shaw that complied with the loan agreement. The court, however, said that Invesco was only entitled to specific damages that were prescribed under the agreement. In particular, the loan agreement contained a mandatory prepayment provision, which essentially said that all unauthorized proceeds received by the subsidiary must be used to pay the existing debt. This meant that Invesco was entitled to an additional $40 million on account of its original first lien loans. Now, Invesco thought this remedy was insufficient and claimed, as I said before, additional damages, maybe described as expectation damages, but the court rejected that. The court said the only thing that the excluded lenders here, Invesco, were entitled to was the remedy provided for under the agreement. Unfortunately for them, that was a $40 million unsecured claim that they would not receive a full recovery from because of the bankruptcy. And an interesting quote I think that we may see pop up in the Serta remand, it's cited at least, is, quote, "There is no need to look for remedies outside the four corners of the loan agreement." So that brings us back to Serta. As Nick said, the case has been remanded on the issue of liability for the breach of contract and damages. The issue of liability, it may be safe to say, has pretty much been decided already by the Fifth Circuit, saying that the transaction did not satisfy the open market purchase exception. The issue of remedies, however, is undecided and hasn't been litigated yet. So it's interesting to note that in the bankruptcy court, the parties agreed to bifurcate the issue of liability and damages. So they never got, because Judge Jones ruled in favor of the participating lenders, they never got to the issue of remedies. So unless there's a settlement, we expect there to be briefing and further proceedings on the issue of damages here. And the one potential avenue, right, is that just like Judge Lopez did in Robert Shaw, he may look to what remedies are provided for in the loan agreements inserted. And I think Nick's going to talk about one of those.
Yeah, let's flip to the next slide. So the excluded lenders brought breach of contract claims against both the borrower and the participating lenders. At this point, the borrower has gone through the bankruptcy. They've received the discharge. You now have a reorganized, company that is a borrower. So I think allocating money damages against the company is probably pretty difficult in this situation. And as Mike just said, as Judge Lopez decided in Robert Shaw, you should look at the agreement and see what it says, right? The bedrock principle of contract damages is that a party injured by a breach is entitled to recover damages that are the natural and probable consequence of their breach. It's to compensate them for the lost benefit of their bargain, right? They should be put in the same economic position they would have been had the breach not occurred. And you could say here, well, they were parties to this contract, so their expectation was to get whatever the contract provided for them in terms of remedies. And Section 2.18C of the credit agreement that you can see here on the screen kind of provides what we think is potentially a viable remedy, or at least a starting point for where Judge Lopez might start the analysis, in which this provision says that basically any lender who receives a payment that is non-pro rata has to purchase for cash at face value participations in the loans of other lenders of the same class at such time outstanding to the extent necessary, so that the benefit is basically ratably shared across the group. So they sort of have, the credit agreement included a mechanism for non-pro rata payments to be equalized across the group. Now, there are some procedural challenges to applying the strict language here, because the loans are no longer outstanding, and it says, you have to purchase participations in outstanding loans. Um, but it's at least, like I said, a starting point. If the court finds that the participating lenders breached the credit agreement by not performing this specific obligation of kind of equalizing their payment. And as we also learned, to just tie it back to the Mitel decision, you might say, well, this was an exchange. There was no payment. They didn't receive a payment, but payment doesn't necessarily mean a cash payment. As the appellate division said in the Mitel case, it can include other forms of value, such as an exchange, a refinancing, or new debt. So presumably the payment received here is the $875 million in new debt, which should have been shared ratably across the group of lenders. And now, whether the court entertains expert testimony and considers whether to go beyond those kind of normal general damages or expectation damages and considers consequential damages, which are like things like lost profits and lost opportunities, I think is a much harder question. If you're in the excluded group, you're going to argue, I didn't just miss out on that, my pro rata piece of that new debt. I also missed out on the opportunity to participate in, any premiums or fees that the participating group received. I didn't get reorganized equity out of the bankruptcy like they did. And maybe you could argue that the transaction also harmed the value of my loans on the secondary market. So, my harm was more than just not getting my pro rata share of the payment. That's, I think, likely. The court's going to have a hard time pinning that down. And if consequential damages are too speculative, generally they're not awarded. And we can look at what Judge Lopez did in Robert Shaw, where he allowed Invesco to file a proof of claim for their prepayment damages, according to exactly what they should have received under the terms of the contract. But he also disallowed the debt and equity damages, as Mike explained, reasoning that they were consequential, and at least in part because they were too speculative. And Judge Jones also, in his opinion, really was pretty clear that he felt like the non-participating group here didn't exactly have clean hands when they showed up to the table, because they had proposed their own liability management transaction before this. They just happened to lose out. So, if the court is struggling between, consequential damages or, just whatever the contract provides for here, I think, it's at least an easy out to say, hey, look, you get what the contract says, but we're not going to go beyond that.
Yeah, that's an important point, Nick. And I think something else that happened in Robert Shaw that may inform on that point. So there was also a claim, right, for breach of the implied covenant of good faith and fair dealing, as there are in all of these cases. And that would, in theory, allow for damages that are different from what the contract permits. The judge rejected that claim. And in rejecting that claim, he did something interesting. He said that because both Invesco and the participating lenders had already participated in an uptier, they set a baseline of dealing between the parties where it was expected that something like this could happen. And as a result of that, one of the reasons why there was no breach of the implied covenant of good faith and fair dealing. And as Nick pointed out, in Serta, there wasn't a transaction that occurred before the uptier, but there were proposals that were submitted, including by the excluded lenders in Serta. So they had their shot in one sense. And that is, an equitable factor that a court may consider when it's taking a look at remedies.
Yeah, I think it's a great point. And so to kind of go back to the menu of possible remedies, that's probably the starting point here. Anything beyond that is going to be a little harder. As we mentioned earlier, the Fifth Circuit dealt with equitable mootness in the Serta decision. Just a little bit of background about the doctrine. It's a judge-created doctrine that precludes appellate review of a substantially consummated plan or a sale because you can't unscramble the end, basically. And it would be unfair to all of the other parties who were involved and, who have potentially transacted with the reorganized debtor thereafter to unwind that transaction. So you can kind of see here some of the elements that the courts consider when they evaluate equitable mootness. Now, the Fifth Circuit cast some doubt on it, but what they actually did in excising the indemnity was pretty narrow. And so, when we're talking about any other remedy beyond simple, expectation damages that are provided for under the contract, such as unwinding the plan or reinstating the liens of the non-participating lenders, I think it's going to be a really, uphill battle, and it'd be really tough for the court to find its way around the equitable witness doctrine in that situation, because it's a little different than just, say, excising a single indemnity provision in a plan. Let's go to the next slide. So you can see here just kind of an illustration of what the Serta plan provided for the different treatments. Class 3, that's obviously the new super priority debt, $200 million in new money. Class 4, first lien, second out claims, that is the $875 million of debt that was exchanged. And so, like I was just saying, the court theoretically may be able to modify the plan. Judge Isger seemed to imply in core that cases like Pepper versus Litton give the bankruptcy court great latitude to do equity and to do what is just and right among the parties. But we think those options are pretty unlikely here, even if simply issuing or forcing, say, the participating lenders to hand over some of the reorganized equity, basically in essence diluting them as if the transaction had never happened. Seems like a neat outcome. I think it's probably unlikely. I don't know, Mike, if you have any thoughts on that too.
No, I agree. I mean, in Cora Westco, as you pointed out, it was pre-confirmation. So the court had more room to do equity, I think, than in this situation where Serta's plan is confirmed, it's substantially consummated. And not only that, the excluded lenders were denied a stay of the confirmation order 3 times. Both they were denied it by the bankruptcy court, the district court, and also the Fifth Circuit. So it would take a lot for, in my view, for the bankruptcy court now to try to do some sort of equitable relief that would affect the treatment of parties under the plan, or classes under the plan.
Okay. Thank you both very much on that. We're nearing the end, and we do have a fair number of questions. So why don't we try to tackle a couple of questions, and to the extent we don't get to them on this webinar, we'll try to deal with them directly. So don't hesitate to keep sending them in. First one, I think this one is probably for you, Meredith. Most of the deals resulting in litigation appear to be in the public credit space. Are you seeing similar LME transactions in private credit deals? Why or why not?
Yeah, I think we are. And it turns really, I think, on one, the strength of the protections in the particular documents. And then also, again, on how negotiated and what the position of the parties are in terms of getting there. And I think ultimately, in terms of the future of LMEs, the upshot from Serta and Mitel is that anything that doesn't rely on the open market purchase exemption is still fair game, whether in the public or private credit market.
Great. Thank you. Here's a question on sponsor liability. Maybe I'll kick it to you, Mike. Are sponsors being dragged into these lawsuits? What types of claims and outcomes have we been seeing?
Yeah, thanks, Ron. So the claims that we've been seeing against sponsors are tortious interference. We saw that in the Mitel case, and a few others. Generally speaking, they've been dismissed early on in the case, either at the motion to dismiss stage or at the summary judgment stage. In most cases, they're dismissed on something called the economic interest exception, which is a doctrine that essentially says if a party has an economic stake in the business already, it cannot be held to have interfered with a contract between other parties unless it acted with malice or illegality. So in a situation where a shareholder sponsor owns the company. It obviously has an economic interest in the company. And for example, in Mitel, was protected by allowing this transaction. It was protecting its interest because it wanted to raise money to address the liquidity concerns and to go forward with the acquisition that it was looking to finance. So in most cases, it's been dismissed. The one case where a claim like this did proceed past summary judgment, but ultimately was unsuccessful, was the Wesco case, and in Cora Wesco, which is what Nick discussed earlier. And in that case, the sponsor, the court found, was heavily involved in the transaction, and also had a piece of the debt. So it was benefiting directly from the transaction as a debt holder. And the court allowed that to go to trial. So that was the one case where it actually went to trial. But there's risk. I think one way to mitigate risk is to make sure you have an independent director in place. And if you're not participating in the transaction in terms of holding the debt, that's helpful as well.
Great, thanks. I think we have time for one more question, and I'm going to find one for you, Nick. Yeah, we attorneys, we spend a lot of time negotiating these indemnity provisions, and they were struck in Serta. So, what are some of the implications of this kind of change? Is this a significant change in risk going forward for parties that participate in these transactions? Thank you for these questions, by the way.
Yeah, thanks. So yeah, I think it is very meaningful when you're evaluating the risk here if you're going to participate in one of these transactions, right? The participating group had specifically negotiated for an indemnity and said, we're willing to participate, we're going to give you money. Obviously, they got a benefit out of the transaction as well. But I'm sure that was a very important part of the calculus for them, was to say, we're going to be indemnified if we face any liability for this, because these transactions are occurring across the market and they're being litigated. And while the litigation hasn't been that successful yet, it's possible that, we'll end up holding at least some of the bag for this. I think it's also meaningful in that the court was willing to excise that from a confirmed plan and consummated plan, right? It has implications for equitable mootness. But I also don't think that the Fifth Circuit really struggled with it. I thought it was pretty easy for them, because they said, this is only going to impact basically just that group, the participating lenders. None of the other third parties who voted on the plan, are getting treatment under the plan, are going to be impacted by this. And so I think it was kind of an easy call for them. But you now have participating lenders who are kind of, hitched to a plan that it's missing a provision that they bargained for. And, it's not like you can just walk away from the plan or walk away from these contracts because they're missing that provision. It was just severed. So yeah, I think if you're considering participating in one of these transactions, you have to think about that risk. And especially here, because the debtor, like we just said, has come out of bankruptcy. I don't know that the court is going to be able to find any liability against the debtor at this point. And so it may all be borne by the participating lenders.
Great, thanks. Admin note, the CLO code for today's program is Future 0129. All right, and that brings us to the end of the hour. We're a minute over. I want to thank my panelists. I want to thank everyone else who helped put this together, and appreciate everybody who joined us today. I'm pretty sure we're going to have a copy of this posted on our website, and we'll take care of all of that in the days to come. Thank you again, and have a great week.